Hello everyone, welcome to our channel Erudition Law. Today we are going to discuss about the introduction to law of tort. But before jumping into the main concept, let us understand what is the purpose of law in our society. Well, the purpose of law in our society is to do justice by preventing wrongs. Now these wrongs can be broadly classified into two categories: civil wrongs and criminal wrongs. Criminal wrongs are those which affects an human being by causing injury to its body, reputation, mind, property, etc. It is so serious in nature that it is considered as an offense against the entire society, and state punishes them with the serious punishments like death, imprisonment for life, fine, imprisonment, etc. Now, on the other hand, there are certain wrongs which are not so serious in nature, but it results into legal injury. That is, violating the legal right of a person. It may not actually cause any damage, but it is affecting the legal right of an individual. Therefore, it is also considered as a wrong. So, law of tort deals with civil wrongs. It deals with civil wrongs for which the remedy is also common law action for unliquidated damages. Now, the law of tort is derived from a Latin word tortum, which means twisted, crooked, or wrongful. Any behavior which is not straight. It is different from contract as well as different from crime. And it must result into a legal injury. That is, it must affect the legal right of another individual. It may not result into actual damage, but it must cause legal injury. What is the remedy for law of tort? The remedy for tort is unliquidated damages. Now, liquidated damages means those damages which can be measured. The amount can be determined. It is a predetermined amount. But unliquidated damages are those damages where the amount of damages cannot be predetermined and it depends on facts and circumstances of each case. Now, let's move on to next concept, that is, what are the essential elements of tort law. First, there must be an wrongful act or omission, that is violation of legal duty. It must result into legal damages, by which we mean infringement of legal right, and the remedy, legal compensation or injunction. Now, let's understand the concept of damnum sine injuria and injuria sine damnum. Damnum sine injuria means damage or harm without any legal injury. That means actual damage has occurred, but the legal right of any person has not been injured. In such case, we do not get any remedy in law of torts. Suppose there is a competitive restaurant opened by two different persons. Now, since the competition is there, one restaurant has to drop the prices of their items, food items. In that case, though they have suffered loss, monetary loss, but their legal right has not been infringed. In such case, he has no remedy under law of tort. On the other hand, even if there is no actual loss or monetary loss, but legal right of a person has been injured, in such case, he is very much entitled to get remedy under law of tort. For example, I have a right to vote, but I have been stopped from casting my vote. But the party for which I intended to cast my vote and the person for whom I wanted to cast my vote won the election. But still, since my legal right has been violated, though there was no damage, but still I am entitled to get a legal remedy under the law of tort because my legal rights has been violated. So, torts can be classified into three types. Intentional torts like deliberate wrongful acts, negligence, that is failure to exercise care, and strict and absolute liability. So, intentional examples of intentional tort can be assault, battery, false imprisonment, defamation, trespass, where some kind of intention or mens rea is involved. Suppose I am entering into a premises knowing that I am committing trespass, or I am deliberately trying to harm the repute of a person. In such case, these are intentional torts. On the other hand, negligence is a tort where I owe a duty of care but I am not exercising my duty. So there is a breach of duty and resulting into damages. That is negligence. Next is strict and absolute liability. This concept is a unique concept also known as no fault liability. Now, why no fault? Because sometimes there may not be any fault on my part, but still the legal right of another party has suffered due to some activity on my part. Though that was not intentional, though I had no knowledge, but the legal right or the injury of the our other party is so grave that in case I have to take the accountability and I am liable. I cannot take any defense that I had no knowledge, I had no intention, there was no fault in my part. Law will make me liable. So in that case, my liability is strict and absolute. So this is the very basic introduction for the law of tort.